will begin with 9.7 from the Controller's Office.
Thank you for your attention to this important I'll try to be brief on the financial piece. The first slide is, this is actually the first time we've gotten from AOPC numbers from them that have excluded the joint and several gross of restitution. That's always been a problem for us in the past, and the restitution would be duplicated or triplicated depending upon how many offenders owed on a joint crime, I'll call it. So those are actual numbers. And the only thing I'd like to point out, victim restitution is slightly more than half of the amount assessed. And that is, by the way, the amount owed as of the end of December 15. So about 51 million. Of that piece, if for anyone interested, about half of it is owed on cases prior to 2011, so 2010 and earlier. The other half, or about 25 million, are owed on cases just within the last 5 years. And the largest and most recent piece is 7 million, still owed from 2015. The next slide shows the breakdown of responsibility for collecting that about $51 million. And this is an estimate, but we think it's reasonably close. Any moment in time, the number could change. So we didn't spend too much time apportioning it. But about $30 million owed, that's the responsibility of probation. 20 million or 40% owed, that's responsible of the new unit. I'd like to point out that for the WCU, they have responsibility once if the case is never on supervision. All the older cases, they inherited per policy. And also any case that probation had that's off active supervision and are no longer collecting on. So by definition, they have more challenging, problematic cases, caseload to collect on.
Can you just, in case it's not clear, what exactly does it mean when someone is on supervision? 2 weeks from after supervision, and why that makes it more problematic when they're not?
Basically, if a defendant is under supervision, there are more enforcement mechanisms against them. They are under conditions not to reoffend. They are under direct orders to meet certain obligations. Once that's, and to remain drug and alcohol free in some cases, they've got a long list of things that they have to do in order to stay out of jail or to stay on probation. Once they are no longer on probation, once that time period that they've been sentenced to probation is expired, many of the enforcement mechanisms go away as well. There's a lot of things you can't do to them once they are no longer covered under probation. And that's a time frame. It's you are on probation for 24 months. Once 24 months is up, generally your probation is over, whether you have paid all this back or not.
What's the criteria? Do the judges consider fines and fees and restitution when they determine the length of probation that somebody is sentenced?
In many cases, the length of the sentence is determined by guidelines. In other words, if you commit this crime, this is what your guideline sentence is. Now, there are standard range, there's mitigated range, but in a lot of cases, it is pretty set. The judge has some flexibility, but not, you can't, if someone has committed and I'm trying to give a good example, a certain crime where the max sentence is 5 years, the judge can't say, well, because you owe $50,000, I'm going to put you on probation for 10 years. They can't do that. The max sentence is a certain amount, and that's just what it is.
These are just guidelines.
The word guideline is less than guideline. It's statutory guideline. Let's put it that way. You can't. I'm hard to explain it because it depends what the crime is too. There's so many variables.
There's mitigating circumstances that allow for judicial discretion But outside of that, if those do not exist, then it has to fall within the standard guidelines for the crime.
Okay.
So the point being that someone under supervision is on probation, the county has a lot more leverage, a lot more direct contact,
Correct.
a lot more monitoring than they do when they're on. Yet the cost, the balance due remains.
Including importantly, while they're under supervision, the probation office actually knows their whereabouts, whereas that doesn't always exist once they're off supervision as well.
Let me ask probably a dumb question. How could this amount accrue to $50 million?
Well, that's actually explained, if we can jump ahead.
Thank you.
Jump ahead to the graph. That's how that gets to $50 million.
It's not at all a stupid question. We spent
No.
nearly, I think, 9 months in the discovery phase trying to figure out exactly that. And it's not an easy question, nor is it a single easy answer.
Good. So you can tell this is from the better part of a bit more than the past decade, and you can see in the early part, I'll just for simplicity call it early part of the decade, we were collecting as high as 45% in year one. And what the data shows that whatever you collect in year one, you collect half of each subsequent year. So you start out collecting 100%, then people kind of have expectations. You're being more assertive, and each subsequent year you collect proportionally higher amount. But when you start out not being, I'll say, as assertive in collecting, such as in starting in 2010, especially 2013 and 14, then your annual collections, your subsequent year collections are also lower. And again, about math works out to about 50% of each subsequent year you collect less. So it's really that, the bulk of the payments come from in the year that line starts to dip down. Proportionally more and more is left uncollected, so that's how we get. That's why I said, I point out on the earlier PowerPoint page that about half the amount owed, or 25 million, is from the last about 5 years.
Okay. Did I hear correctly that when a criminal is on probation, when they're off probation, it's more difficult to collect than the unpaid amount?
Yes.
Okay, why can't we ask for that amount up front before probation ends? Or do we? Or is there a law that states we can't?
If they are unable to pay the full amount, the statute sounds much more legalese, but if they are unable to pay the full amount, we are legally required to offer them a payment plan that they are able to pay. So if you have someone who, for instance, is unemployed, and they owe $20,000, they don't have the ability to pay that, so we are obligated to get them a payment plan that they can pay. Now, in the past, in many cases, they were looked at one time, and it was a resource issue. This is not we totally don't want to collect, this was a resource issue. So, the defendant would come in, and they'd look at him, he's unemployed, and they would say, okay, can you pay $10 a month? Yes, I can pay $10 a month. Well, 10 years go by. In the meantime, this gentleman may have gotten a job, may not have as well, but some of them don't. May have gotten a job, but is still continuing to pay what they were ordered to pay, $10 a month. One of the things that's been implemented, I may be jumping ahead, but I'll say it, is the ability to pay hearings that are now being done by the collections unit, that when a defendant comes in, rather than just saying, what can you afford to pay, we're actually assessing what their ability is. In addition, if they are given a minimum payment, a $10 or $25, they're coming back in a few months. They are making them come back in 3 months, 3 to 6 months. Right, depending on the circumstances, that defendant is ordered to come back in 3 to 6 months, and we're going to reassess their situation. So rather than just, you paid your $10 and you keep paying, and that goes on for a decade or more, we're making those minimal payment people come back and be reassessed and look at their situation again until we get them to a more reasonable payment.
Is this something new?
This is new.
Okay.
This is within the last
This is
just couple months.
implemented in March.
All right. Let's.
Just so I understand the numbers again, Mike. So the 15 million owed, is that the amount owed just over the past 10 years?
No, that goes back into the end of the 80s, early 90s. We got a report from AOPC on that. That's as far back as they went. It took them quite a while to generate that report. So, we consider that kind of a final word on the balance themselves.
But Mike, you said about half of that is 5 years.
Half of that is the last 5 years, and to be explained by the dip in collection success.
And the only reason I asked this is to clarify is because you said this chart, whatever page this is, with the graph, explains where the 50 million came from.
Yeah, our office did not start charting data until about 2004, first year on that particular graph. If we would have went back, I actually don't know what prior years looks like, so we only have the 11 years.
Dennis got his hand up, maybe you can answer it.
Well, I just want to say that prior to the county going to Infocon, the probation office did all the accounting and collections. Whenever Infocon came aboard in late 93, early 94, everything that the probation office had outstanding those cases were all entered, back entered, so to speak. So that's why that figure goes back into those time frames. And everything that was to collect is in the system.
I'm just trying to understand because it seems to me we ought to have a record of everybody who owes money to the county. And, we ought to know who those people are.
We do.
But Mike's saying now we only have records going back to.
Well, I was talking about the report we got from AOPC. Denny, I think.
The report from AOPC is everything is owed because
Everything is summarized.
Is the $50 million owed, from criminal defendants for restitution and fees and fines, is that all that is owed in the history of the county?
Yes.
All outstanding as of right now, yes.
So nobody has fallen off the radar?
We should all know this.
But getting back to Vince's point, imagine if a big company like, say, Sears, who does a lot of this stuff on credit cards and time payments, had no accounts receivable operation whatsoever. When we came into our discovery phase, when these numbers were put in front of us, what we saw was that essentially the county had no sustained, consistent, or effective accounts receivable management policy whatsoever. And while there were lots of options, the options weren't being pursued, and there was no accountability in many quarters for this function. And that's how this whole thing came together. Essentially to try and put an effective accounts receivable operation into place with, instead of paying back for washing machines, it's cost fines and most importantly restitution to victims who without that accounts receivable, because of limitations of the law, meant that none of that money was coming either into the counties or to the victims of the crime.
Does interest accrue?
No,
Accrue.
it doesn't do that.
I'm talking today.
No.
And why is that?
I don't think we are legally allowed to do so. I would disagree, and if the law could be changed, I think that would be fabulous, but I don't believe there's any mechanism in place for charging a defendant. So basically, defendants have an interest-free loan. But that's the law.
Well, that doesn't provide any incentive.
No, it doesn't.
But takes
I do not
away
disagree.
the key incentive.
Yes.
It does incentivize us, I would suggest, to try to collect it earlier, understanding. So I look at this graph, and I think it tells us two things. It tells us we've been doing a more dismal job of collecting over the past decade. But at the same time, it shows us what our potential is to get back to. And I say that looking at the high 3 years, for example. Your child, for example, as an analogy, will say, I'm afraid I'm not going to be able to do so well on this test. Well, you may reference back, well, you've got these or these on that subject matter in the past, so therefore you can do it again. We have 3 data points at around about 40-some% at the beginning of the decade. Those average, say, about 42%. The average of the most recent 3 years, 2013, 14, and 15, is 27%. If we would have been as successful in the most recent 3 years as we were at the beginning 3 years of the decade, we would have collected an aggregate total sum of $2.7 million more than what we actually did. And that's just the county piece. The victims of crime would have gotten a likewise increase, which is very important to them. So, and it's coincidental that 2.7 million was the amount, I believe, of the county's last tax increase. So there is a great deal of potential here demonstrated by this graph. First, to kind of continue it, I didn't chart 2016 because we don't have a full year, but if it was charted out at the current rate, you'd see a slight uptick in that red line into the 2016 column. Next page. This shows 1 year the success the courts have had in collecting in 2015 and 2016 to date. In 2015, collections increased 7.5% overall, and in 2016 to date, they're up 2.7% overall. So we're headed in the right direction. Restitution in 2016 is down about 8%. One thing I like, and that compares favorably with the 19.5% increase in restitution collection the prior year. One thing I need to point out in regard to restitution, there's a lot of variability in restitution because generally the amount swings year to year in terms of the amount awarded by the court based on just a handful of very large cases. So what happened in 15 was that 2014 restitution awards, that was a low year for the court. Not criticism of any judgment of the court, they just didn't happen to have a lot of high-value restitution cases come before it. So then, therefore, there's a big spike up of about 50% in restitution awards in 2015, which is likely to account for that such a large increase in restitution, in addition to the practices that have been put into place. So we're trending so far to come in lower than we did in 2015. But we can see we're about holding our ground in terms of restitution and collection. So just a bit of data to put that in perspective. Something data that I don't have charted for you that I'd like to share nonetheless is I looked at aggregate receipts over the past decade in total, not just first year, but in aggregate. And Cumberland County's collections are up in aggregate, again, this includes victim restitution, 47% over the past decade. But to put that in context, that's 47%. Restitution in most years over the past decade has been up 2 to 3 times what it was at the beginning of the decade. And the county share of assessments, the amount that is owed by offenders to the county has about doubled. So, that means that our collections are only up about 57%. We've certainly been less effective over the past decade in collecting. So it kind of gives a similar story to the graph that I showed you earlier. As a point of benchmark, though, we had roughly modeled our collection efforts after what's going on in York County. York County collections are up 300% over the past decade. Their overall collections have went from $4 million, 4.2, to almost $12 million. They implemented a slate of new collection practices as is exemplified, similar to our practices in our court approved policy.
We had the judge that was in charge of that, Judge Kennedy, come and speak to our judges. And that resulted in our adopting the policy Judge Hess put in place that essentially mirrors York County's policy.
I'm not suggesting that we can mirror a 300% increase, because I think in York's situation, their circumstance, they started at a low point, whereas for, in comparison, we started at a high point about a decade ago. But I am suggesting, as the other data indicates, that we can, I think it's reasonable to expect that over time, we can double our collections from where we were at, just based on how we've done in the past in the high for the year.
Concepts being proven in York County, that these techniques can work. And they're proving it. We modeled off them in many, many ways.
That's it, the Lori to talk about election matters.
All right, so if you recall, we finished 2015 at approximately $211,000 for the year. The first 6 months of 2016, we are respectively sitting at $160,000 to date in collections. If we break,
That's through June 30 then? is that-
yes, that's correct. If we break down what that $160,000 looks like, you'll see that almost $73,000 of it was in established payment plans. A little over $13,000 of that was collected on old cases. And by old cases, we mean cases that are 10, 15, 20 years old, have long since expired on supervision, and still owe fines, costs, and restitution. An additional $5,500 was collected in cases that were paid in full that we did not have established payment plans for, bringing us to almost $78,600 for the second quarter. It's slightly down from the first quarter by approximately $3,000. We are attributing that to we had better success in the first quarter with people receiving their income tax refunds, and we were more proactive of taking advantage of that time period. The next slide that you see, this is the tools of the collection policy that was adopted October last year by the Board of Judges and received your blessing on. These are all the tools, and the order in which they are most cost effective is the order in which they appear on this slide. If you look at the next slide, you will see that this is currently how we have been implementing those. And as you see, we have a situation where we kind of have the horse before the cart, so to speak, and not utilizing the most cost-effective methods, but rather focusing on time-consuming methods, but yet are yielding faster returns.
Or the wage attachment, is that voluntary as opposed to
That's correct, that would
a
be voluntary.
judge's order? It's not a judge's order.
It is not something legally that we are allowed to do at this time.
There is pending legislation
Correct.
to make a judge be able to order that, but it is currently not permitted. The defendant has to agree.
I think as you look at these, you'll note the bottom three. We discussed the ability to pay assessments that are currently being done by my unit. There was recent changes to Rule 705.1 in restitution, where the Board of Judges are now responsible for putting in a payment plan into a court order at sentencing. So the ability to pay assessments initially were being done at the request of probation with people who needed to be financially assessed that felt they had limited resources. Now we will also be assessing all restitution cases as well to be sure that we are maximizing the dollar we can collect from defendants who do owe restitution. So the number of referrals that I will be receiving is currently at 174 since March of this year, is about to double, if not triple, with that responsibility. And to give you an idea, the average assessment when I receive all the paperwork takes approximately 30 to 45 minutes to complete, and it is a formula. Above that, we have the bench warrants, which, as you know, we use the constables for, and they have brought in an additional $20,400 to date. Again, it's time consuming issuing bench warrants, finding people, and bringing them in front of the judge for contempt court with Judge Brubaker, but it does seem to yield a faster return on our investment. The problem is we're not able to have the time to focus on the less cost-effective resources, like sending out delinquency letters, getting people that are currently on that payment plan the option of a direct debit or a wage attachment. That is rarely addressed with our time constraints. The collection agencies themselves, as you know, recently signed contracts with us. I'm in collaboration with the AOPC to get them set up. The problem is the data needs to be reviewed before those cases can be referred to them. Obviously, I don't want to send them cases where there's restitution when we want to keep those in-house and focus our own collection efforts on those.
Lori, just a quick clarification, bench warrants are also done by the sheriff's department too, correct?
Correct.
Yes.
Yes, as a collaborative effort with the sheriff's department, my apologies.
Did you say the new collection agency is not really collecting yet?
They are not yet collecting. They are in the process of setting up with the AOPC to receive data, but I have to find time to review the data that we are going to be submitting to the two of them.
We'll get into that in more detail.
Yes.
Okay.
And the driver's license suspension, of course, is an additional resource that your county has found great success with. Unfortunately, we have not had the time to even attend training for it, let alone do the data entry and the tracking that's required to implement that. So it has at this time been put on hold. We're again hoping to get to that. The next slide points out additional tasks. I thought this was relevant because, as you know, the first year I came on board was spent writing policies, trying to get the policy implemented and trying to get things up and running. We've had great success. However, with that success also comes additional projects. With that came exoneration policy, countywide policy that the judges asked us to write. This is a matter of trying to look at these very old cases. We'd be talking cases from the 70s, 80s, to find out if the defendant is deceased, if they're in long-term care, being terminally ill, if there is no valid reason to spend time and resources on trying to collect money. This is a policy that addresses those cases and will clear them from the books, so to speak. The bail forfeiture procedures and collections was a collaborative effort. I was asked to join in with the solicitor's office, Jen Hipp. She is going to be, as I'm sure you know, receiving all the petitions on the bail forfeitures for any of the bondsmen who petition for an exoneration and produce an argument on behalf of the county in opposition of that. My part in that will be the actual collecting of successful bail forfeitures and monitoring them. As we explained, Rule 705.1 is the changes to restitution and the increase in the ability to pay assessments that will need to be done as a result of that. You're familiar with the third-party contracts, as well as I've been before you with the software contract for TLO, and there are some additional software contracts that I will be coming before you with in the near future. Again, additional tools and resources that we need to track these people down and figure out what their availability to pay is. The last one is the Amnesty Day. That's an interdepartmental collaboration. Currently, we have it scheduled for October 20th and 21st. We are setting up a subcommittee to get that together, but basically what we're trying to do is address any cases where defendants owe restitution any cases where defendants fail to appear for a court hearing, as well as any defendants who are not in compliance with the conditions of probation and parole. The idea is we are not exempting them from the money that they owe, but rather trying to get them in and get an assessment and get them on a payment plan without them having to fear incarceration. And I will be providing you with a informational card at the time we do the press release on that, so that you will have answers to any questions or concerns that may be posed to the board.
Danny's had his hand up for about 5 minutes.
I just wanted to point out that before it even gets to the collections on the bail forfeitures, another step that's often in there is that the bail bondsman applies for exoneration to be released from the forfeiture. And my office, cases specifically, has been very good at providing information to the judge that you wouldn't necessarily have the opportunity to see. The bail bondsman doesn't always tell the exact truth when he's applying for the exoneration. And that's why several cases that we've had that would have been exonerated sometimes non-exonerated and then went on to collections.
Which is why Jen Hipp will now be responsible for being copied on that correspondence and representing the county.
Excuse me, I found it interesting that in 2015, the county received about $2,000 for bail forfeiture, whereas in comparison, York County received $102,000. So it seems like there's a lot of potential there to improve things.
So the next slide looks at summary and trends. Where have we been? The last time I was before you, we discussed the pilot project and the 2-year date. If I recall, based on my best information, the pilot project after 2 years would be slated to end in September of this year. What I'd like to present to you is that we have proven the concept with the interdepartmental collaboration that we have, the approved collection policy, the judicial participation that we have, and the overall, however, slight increase in collections. So with that, where are we heading? We want to continue to increase the focus on collections, broaden the scope in being able to utilize the more cost-effective tools, and also provide the additional resources needed to get the job done. Part of the additional resources that are needed is Missy, after almost 22 years with the county, has expressed a desire to retire in the first quarter of 2017. With that being said, we would like to respectfully ask to have somebody in place prior to that she would be able to train and work with and be ready to replace her at the time she chooses to depart. Having that additional staff member will also assist us with some support in covering the office, as we've received a few complaints of there's no one in the office, we're not returning phone calls in a timely manner, things along that time. Whether legitimate complaints or not, it is true that Missy and I are constantly in and out of the office working on the tasks that we previously listed. In addition to that, I'd like to request to hire a temporary position. This would be a project-oriented position that we would be looking at. The projects would be the debt collection agencies and Amnesty Day. In collaborating with the AOPC, as I reported earlier, they supplied me with a report that lists approximately 9,500 cases that need to be reviewed. These are cases that may be eligible based on criteria to be referred to the collection agency, or they may be cases that there is restitution owed, and in which case we would be using them as a target for the Amnesty Day project. I unfortunately cannot find enough hours in a day to go through 9,500 cases.
So that's an answer to your question.
Mm-hmm.
We went through the RFP process, we made the awards, and this is sort of the ramp-up phase. Part of it, to get them going, is that we have to go through the state, answer the request for the town's position.
Maureen, just explain to me the process involved. We received from AOPC 9,500 cases. What do we have to do before we turn it over to the collection agency?
I need to look at those cases and ensure that they are no longer on supervision, first and foremost. There is no identifier in the system that they can pull from that will tell us whether or not it's a supervised case. Obviously, if the case is under supervision, we do not want to refer it to a collection agency at this time. And if there's restitution, most importantly, it's a case we should be targeting for amnesty day.
There's no way that can be
The
tagged,
CPC
you know, like.
Adult probation uses the UCM software. That software does not speak to AOPC in that regard to identify cases that are on supervision.
And that is not a fault of UCM. That is AOPC does not allow outside databases to talk back to them. CPCMS will send data out. As a general rule, they do not receive data back. With the exception is like JNet, but that's another state. That's a government program. So.
It seems to me, that's an issue that hopefully, should be addressed at the court administrator's office with respect to, why we have to expend time and effort to go through these cases and tag them as to whether or not they're in
Because
supervision. If there's a way to do that electronically.
CPCMS does not do that.
Like this was electronically, Mike and I actually had a conference call with the AOPC and set the criteria of what we were looking for. And this is what they managed to narrow it down to from the thousands of cases that exist.
Right, this isn't a process that we could turn over to the collection agency.
Because the collection agency isn't going to know if the defendant's on probation or not.
Right.
We can't just share the information with them and say, go look it up.
Where are they looking it up?
Well, I don't know, wherever you're looking.
They're not going to
at.
have access to CPCMS. CPCMS is not permitted. I can't give anybody who doesn't work in the courts access to CPCMS. I can't give you access to CPCMS.
The problem here is that AOPC is the guardian of highly sensitive and confidential information. Now, how intelligently they carry out their guardianship is certainly open to question, but they have first, middle, and last say in who can get into that data. And unfortunately, for love of money, no one else really has much leverage. And when things like efficiency or cost efficiency are raised, it tends to fall on deaf ears. They put their control of this and sort of the way to justify this because it's security and the confidentiality of the data that trumps unintended, that trumps everything else or supersedes anything other consideration.
Lori, one of the things you have here for the temporary position is, I guess, reviewing some of these cases.
Correct.
Where do you see that temporary person coming from? Temp agency?
Potentially.
And this is not a involved thing to do, it's just a time.
Correct, it's just a time-intensive thing that would allow us to, A, get the collection agencies up and running, and then it would just be a matter of finding time to manage them, and two, it would give us the target list that we are hoping to publicize prior to amnesty day, so that people can be notified that we want them to come in and get on the right track with us.
This was purely a clerical response.
Correct,
Is there conservative at all over the sensitivity of the information that the individual was saying? Is that strict?
We can request the background check on this.
Yeah. I mean, basically, this position would be sitting in my office at a desk with a computer, Everything's in place with the exception of the computer. There will be no cost to the county for that. IMTO agreed to find us a computer that would do this for us. It may not do much else, but it would at least do that for us. Right, there would be like no internet access or anything along that line. We're not looking to supply that. Just strictly looking for someone to come in and assist with reviewing this caseload.
And the AOPC system is not web-based.
It is, but I don't think you need, it's through a portal with the county. There's like the access certain, I'm probably saying it completely wrong, but there's access, you don't have to have internet access to get it because you go through a portal that the county has. And that portal is what connects over to the state. That makes sense, so I'm pretty sure that's how it's set up.
It's much more highly restricted.
Yeah, yeah.
But it's not like it's accessible just from somebody's home computer or something like that.
You have to be, we actually, in order to get it, I have to put an SRO through to IMTO to have, even to have the icon added to, Missy's desktop. And then you go through permissions processes with AOPC, you have to fill out a form and who you are and who you're working for and
Person
what
needs to
department.
be on site here.
Right, yeah.
And the alternative is if you have Missy or Lori do it, then they wouldn't have the time to keep going right, the pursuit of collection. So it seemed like a good investment.
There's a question about the amnesty day, and essentially that's to get folks on payment schedule.
Right.
If you were to look back over the past year, let's say, of people that we've gotten onto the payment schedule, what percentage actually keep that schedule?
That's a good question. I think currently, for the most part, we do pretty good. The biggest challenge we find is when they do miss a payment is getting that delinquency notice out right away. We, per policy, anticipated being able to do that every 30, 60, and 90 days. Currently, with the time constraints that Missy and I have, our days it's 45 days or more before they're getting that first notice they missed a payment. Now, the good thing is word of mouth has gotten out about the warrants and the fact that we do exist. So I don't know how many times people have missed a payment or they're going to be late and they're actually calling in to let us know. I don't want a warrant issued. I'm going to be 3 weeks late with my payment, or I can't make it this month. I'm going to double up next month. We have the ability to case note that so that the next month when it comes to the first of the month, if that double payment's not in or whatever they promised, we can then respond accordingly.
Yeah, I was just thinking about, it'd be interesting to see whether we have any data on that relative to those people who say, they agree to the payment schedule and don't keep it. Or they miss a month or they miss 2 months. And whether there would be a way for us to utilize the wage attachment or the debit card as a way to enforce or encourage that they make their payments on time.
Right. Now, I can tell you that Missy and I do both have access to the value payment system, so anytime someone calls in, we are always more than happy to process a card over the phone, whether they have a warrant or not, even if they're just making their monthly payment.
I guess what's going through my head, I don't know whether this makes sense at all. So let's say the payment schedule says that I'm going to pay $50 every week or something like that. And you say to him, well, it's $50 every week, but I'll tell you what, we'll make it $45 every week if we either can make an automatic deduction from your debit card or an attachment to your wages.
Oh, yes, we absolutely negotiate with every single defendant that we come in contact.
That would give them an incentive to actually have the automatic withdrawal happen so that they can't come up with a reason
Correct.
as to why we couldn't make it this month. It's just going to come out of their paycheck, or it's going to come out of their...
Yes, we do offer that, and then on the other side of that, we also...
Would you offer discount?
We tell them that we will drop their payment plan, $5 or $10 a month, depending on their ability to pay. if they sign up for a wage attachment or a direct
But
deposit.
you're not reducing the overall.
Absolutely not, no.
obligation.
It's gonna take longer to pay it.
Right.
Right.
So we're guaranteed
Sure,
that
we're offering a
it's
discount, we're not taking a hit on it.
with no
No,
interest.
no,
no
I-
interest.
yeah, I mean, that's what, I wasn't suggesting you reduce the overall obligation in any way.
Right. On the
What I'm
same.
saying is that we actually might be able to get the payments where otherwise we might not.
Absolutely, because our goal is to just get steady monthly payments coming in every month regardless of the amount, which is the whole premise behind the ability to pay assessment. Is if I've done the assessment and I say, this is what you can afford to pay every month without creating further hardship for you or your family, there is absolutely no reason that payment should not come in every 30 days. If it doesn't, then we absolutely have every right to pursue delinquency on you because you are just willfully not paying.
How many of the folks who have payment schedules are having their wages attached to where we have an automatic withdrawal?
A lot,
Excuse me?
a lot.
A lot.
I don't know exactly how many we get checks every day from
Yeah,
companies.
I think that would be good to know.
I think in setting, trying to create an accounts receivable management system where there really was, you need a bunch of stuff. Number one, you need to be able to track data. Number two, you need consequences for non-compliance. And three, you need the tools to which to pursue it, including the systems and the negotiations and other things to be. But without those consequences, why should I bother? If I went in, bought a refrigerator on time, and no one ever sent me a bill, no one ever called me to remind me, or no one ever sent the person out to take the refrigerator back, why would I bother? So I think what's been done over the last year is to put all those three key pillars of effective accounts receivable in place.
Now, the issue now has become a resource issue. There are only two of them. And Lori, I don't know if you said the number yet, but the ability to pay assessments. We did figured out how much time that takes her a month, and if you recall, she said that could possibly double or triple. We calculated how much time she spends currently on ability to pay, and it's 7 to 10 days a month in staff time. So if you double or triple that, that's a whole person just doing ability to pay, and that is actually going to be like, yet again, another unfunded mandate, but something that's going to have to be done for courts.
But the key to remember is that an investment in this has a positive rate of return. We've established that it is not only possible but likely that the investment will pay off positively, and that is with a concentration of effort on the more expensive means of collection. If we increase resources and focus on the less expensive means of collection, our rate of return, as well as our absolute rate, should increase.
The driver's license suspension is done all the time categorically at the MDJ level in Cumberland County. It's not done at the Court of Common Pleas, and that's a subject matter we're talking
Done
about.
domestic relations as well.
Done
Very
domestic relations
very
and-
successfully.
It's a matter of course. York County, of course, they have a bigger population, more court volume, but they brought in 2015, $720,000 just as a result of the driver's license suspension. That's twice the number we're hearing that the new unit is expected to bring in total. So there's enormous potential if we can just get to those other items. I'm also concerned, I noticed that York County sent out 34,500 delinquency notices. But Lori isn't able to do that now. And I got to imagine if you're an offender, you're thinking people aren't watching when they fall delinquent on the payment plan if they're not getting notified.
We've got a great policy in place. The collection policy, I think, is good. The problem is that right now, we can't actually implement all of it in the way that it should be implemented because there just isn't enough time in a day. With just the two of them, there's not enough time in a day, even with them working, I know Lori works well more than 37.5 hours a week. And it is not enough time. There's not enough time for the two of them to do everything that needs to be done to fully make that collection policy work the way it should be working.
And I think it's also important to note that with the ability to pay assessments, the results of that do not directly impact the WCU positively or negatively. I get no credit for that those payment plans that I established early on in the collection process actually will show up under adult probation under first year of collections.
But
Showing the increase in collections overall.
two quick points. Number one, the ability to pay is absolutely essential to this whole process. And the reason is, one of the excuses used for not pursuing collections is that person will stand up there and say, I can't afford it. Well, that could be somebody making $150,000 a year, it could be someone making $20,000 a year. This provides, using U.S. government's related standards, an objective basis to determine what is a just and reasonable amount to ask. Secondly, it's like the old economics 101. We thought it makes sense to add additional resources as long as the marginal revenue you can generate from that is greater than the marginal cost. So we're somewhere early in the curve with we can generate a lot more marginal revenue as we add additional factors of production, and we do so prudently, parsimoniously, and judiciously to make sure that this is working and not just building up a lot of staff that don't produce results. But again, just like in any other economic thing, as long as that marginal revenue increases, hopefully at a greater rate than the cost, the additional cost, it's an economically sensible thing to do.
Lori, when do you see these collection agencies being up and running on an estimated timeline?
According to the AOPC, they will have them ready to go in less than 30 days. It will be a matter of that means they will be able to receive and return data and be ready to be managed. The problem is I need to get that through that report to get them the initial data.
And the temp person will help do that.
Correct.
Okay, now, can these collection agencies help out with delinquency letter production, or is that something?
Yes, we are absolutely looking at them as a pretty much like an additional resource to our unit because they are going to be working cases instead of cases sitting there waiting for Missy or I to get to them.
But they only send the notices on the cases that Lori sends to them, not the ones that we retain. So we'll need to set her up on the notice.
Right. Can you just speak up if you have a question? I'm sorry.
I just wanted to know, are these two new ones, or what's going to happen to the current collection agency?
The current collection agency is being worked by Chuck Bear in adult probation, and he has slowly been recalling the cases back, attempting to locate these people, and if he's not able to locate them, then transferring the case to my office.
So your department will have two separate ones from one they have, and maybe theirs goes don't go away?
Correct.
Okay.
And if you recall, the reason we chose the MSB was because they are able to send and receive large amounts of data. They have great capabilities in processing large amounts of data. Credit management company, although smaller, currently works with 11 other counties on collections of fines and costs.
Have you been down on how well they've done with those other 11 counties?
I can only tell you that when I called for references, everybody spoke very highly of credit management company, including York County, which is who we model our collection policy after.
If I recall correctly, MSP gets notices out, I think, within 3 days of the delinquency. So I like their speed in this one.
Seems like things are slowly ramping up.
It's ramping up. Missy and I personally feel like we've hit the brick wall. I don't know that we can spend anything more, but not for lack of effort, certainly.
No, no. Don't mean that at all.
Any questions or comments? Anybody in the audience? I want to again thank, this is truly a collective effort, and we do want to thank the Sheriff's Department has been essential. This stuff we couldn't have gotten to the warrants being as effective as they are without their cooperation. The courts for their role in all this, and of course adult probation, which is an integral part of this effort, and an integral part of group that oversees all this. And of course, the victims, which is the reason why we're doing, the main reason we're doing this.
I'll thank you on behalf of the department for your efforts, public service.
Mike, can you tell if there's been any effect of the judge's decision to pay all private restitution 100% before anything else?
I'm a better year end when we have a whole year's worth of data. I have kind of trends, but I don't have it at 6 month or intervals. So at year end, I'll be able to tell that more easily than I can now.
Anybody else have anything else to bring up or comment? Danny, I'm sorry, next time, yeah, I can,
Okay, no problem.
my eyesight's bad enough. All right, well, thank you all